everyone, welcome back to UPSC Prelims PYQ analysis series by Drishti IAS. This is the third episode of the series. Herein we'll be continuing with the discussion on the polity related PYQs. We have already covered the constitution, fundamental rights, DPSP, fundamental duties, this part. Other than that, in the second episode we have covered the legislature and the executive part, and in this episode we will be talking about the judiciary and local self-government and some parts related to the constitutional and the non-constitutional bodies. And other than that, we'll also see some of the miscellaneous questions. Okay, so with this episode we'll be finishing polity, and after that we'll be continuing with the history section. Okay, so stay tuned with us. And other than that, there was this query with respect to the PDF. We will be uploading the PDF, so stay tuned with us. You can go in the description, and there is a Telegram link which is there. You can join the channel. We'll start the uploading of these PDFs soon, so stay tuned with us. With that, we'll be starting with the discussion over here. Before that, there is one more thing I would like to tell you, that there will be a question which will be pinned in the comment section. That is your mock question. So after this particular discussion, you can go and solve that particular question and answer to us in the comment box. Okay, so let's start with the discussion over here. This is the third part of the polity PYQ analysis. Okay, now let's see. First, we'll be seeing with the Indian judiciary. So start with the first question. So the first question is, a writ of prohibition is an order issued by the Supreme Court or High Court to. Okay, so now they are saying that to whom this order is issued. Okay, so let's see. Option A, a government officer prohibiting from taking a particular action. Okay, now with the term that is prohibition, that means to forbid. Okay, that means to forbid. Now the problem is that here you are seeing that a government officer is being prohibiting from taking a particular action. Okay, now that is there. Now when we talk about the writs, you should remember that a particular writ is being used against which particular authority. Okay, so now when we talk about the prohibition is not against the government officers, so that is why this option is incorrect. Coming to the next one, parliament or the legislative assembly to pass a law on prohibition. Again, this is also incorrect, because that is a direction which has been given to the parliament or the legislative assembly. That is a mandamus. Okay, maybe a mandamus, because mandamus means that there is a particular government body wherein you are directing them to perform the duty for which they are responsible. Okay, not particularly this one, because here they are giving direction to the parliament or the legislative over here, so that is also not true. Coming to the next one, the lower court prohibiting continuation of a proceeding in a case. Now that is your right answer, because when we talk about the prohibition writ, that is generally issued against the judicial bodies or the quasi-judicial bodies. Quasi-judicial bodies. Okay, so option C is your right answer. Now let's see the discussion over here. When we talk about the explanation, you can see the prohibition is basically, when we talk about the literal meaning of this word, that is to prohibit. Okay, and now here you can see it is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping the jurisdiction that it does not possess. So basically what they are saying is that if they are going against their jurisdiction, so that kind of writ will be used over here. Now you can go through this. Here we will be seeing a comparative analysis in the later parts. So here you can see constitutional provision. If we talk about, so we have article 32 that is talking about the writ jurisdiction of Supreme Court. Okay, and then we have article 226 that is talking about the writ jurisdiction of High Court. When we talk about the writ jurisdiction, High Court has the broader jurisdiction than the Supreme Court. Okay, so here when we talk about Supreme Court can only issue writ when there is a violation of fundamental rights. Okay, Parliament can empower any other court to issue the writs. However, no such provision has been you can say made till now. So as of now, Supreme Court and High Court can go for the issuing the writs. Other than that, under article 32, Supreme Court is constituted as the defender and the guarantor of the fundamental rights. So that is why we are saying that if there is a violation of fundamental rights, then only Supreme Court can go for the issue of the writ. Now talking about the article 226, herein High Court can, in other matters also, they can issue the writ. Okay, so that is why that becomes important. Now, before 1950, only the High Courts of Calcutta, Bombay and the Madras had power to issue writs because of the, you can say, when we talk about the colonial governance, after that, these three High Courts had this jurisdiction, and after that, that has been made available to the all High Courts. Okay, so that is there. If we talk about the comparative analysis over here, which is given over here, before that, we will be talking about the characteristics, and Supreme Court and the High Court, we will be discussing the difference over here. Purpose of issuing the writs, that is only to enforce the fundamental rights. When we talk about the Supreme Court, for High Court, it can be to enforce any legal as well as fundamental rights. So here we can say that the jurisdiction is broader for the High Court. Okay, coming to the next one, writ can be issued against a person or the government Now, when we talk about the Supreme Court located anywhere throughout the territory, they can go for a issuance of the writ, because when we talk about the territorial jurisdiction of the Supreme Court, that is throughout the country. Okay, coming to the High Court, they located only within the territorial jurisdiction of the High Court, for whatever area that High Court is there. So in that particular area only they will be issuing the writs. Coming to the next one, right to refuse exercising writ jurisdiction, that is not available, because Article 32 is a fundamental right itself. Because when we talk about Article 32, that is the constitutional remedies, that is the fundamental right. Supreme Court cannot deny that particular right. So that is why that is a compulsion. If someone is coming to a court and asking that my fundamental right has been violated, Supreme Court has to issue a writ. Okay. Coming to the High Court may refuse, because here not only fundamental rights, but they are also going for the enforcement of the legal rights as well. Okay. So considering that, here you can say the Supreme Court is bound by the fundamental right over here. Now coming to the comparative analysis, here you can see when we talk about the writs, there are different types which is there. So one is your habeas corpus. When we talk about habeas corpus, that means that direct the release of a person detained unlawfully. If there is a unlawful detention of a particular person, so in that case Supreme Court will guide you, or the High Court will guide you, saying that you have to release them. Okay, so that is habeas corpus. That means that to produce, okay, produce the body. That means that a person or a body which is there in the unlawful detention, that should be produced with in front of the, you can say, court. Okay, so unlawful detention, if it is there, so you can go for the habeas corpus writ. Against whom you can issue this? So against a public authority or a private individual, you can go for it. Okay, and against whom you cannot, if there is a lawful detention proceedings, whenever we are talking about the contempt of court, etc., if there is a lawful detention, then there is they will not be issuing the writs. In the case of the preventive detention, etc., they will not go for the writ. Okay, so that is there. Now you can go through this part of the section. I'll be talking about this because when we talk about this, that is basically your static. Okay, so let's not go into details of that. So mandamus, if we talk about, that is to direct a public authority to do its duty. Against whom you can go for this writ? That is a public body, corporations, an inferior court, tribunal, or government. Okay, then quo warranto is basically to direct a person to vacate an office assumed wrongfully. If there is a person who is holding an office without a warrant, without an authority, in that case this quo warranto will be issued. Okay, then moving further, then we have the prohibition writ. Prohibition, we just saw that prohibit a lower court from proceeding in the case. It will be issued against judicial or quasi-judicial or the administrative tribunals, etc. Then coming to the next one, that is certiorari. Certiorari is basically a writ which is issued by a higher court to remove a proceedings from the lower court and bring it before itself. If there is a proceeding in which the higher court is interested, so they can issue a certiorari writ and they can stop the proceedings in the lower court and assume the matter for themselves. Okay, so they will call that particular case file to in front of them. Okay, so that is your certiorari. Only a statutory or the constitutional public office is there, over there they can be issued. Okay, so that is about the writs. Now let's move further. With reference to the writs, we have already talked about the writs. Here you can see in 2022 they have asked a question, in 2024 they have asked a question again. Okay, so that is why this section becomes important for you. With reference to the writs issued by the courts in India, consider the following. Mandamus will not lie against a private organization unless it is interested with a public duty. Okay, so that is true. When we talk about the mandamus, that will not be going for the private organization, but if that private body is doing a public function, in that case it can be issued. Okay, coming to the next one. Mandamus will not lie against a company even though it may be a government company. Now we will be talking about that later. Then coming to the next one, any public minded person can be a petitioner to move to the court to obtain a writ of quo warranto. Now when we talk about the writs, we have already seen that who can actually go for over here. We have already seen that who can against whom that particular writ can be issued and against whom it cannot be issued. Okay, so here we are talking about the mandamus. Here you can see mandamus, it can be issued against a public body, corporations, an inferior court, tribunal, or government. It cannot be issued against a private individual or body which is having a discretionary duty, against whom also you cannot, contractual obligation is there, then you cannot, president, governor, or the CJ of the High Court acting in the judicial capacity, against them you cannot go for a writ of mandamus. Okay, so here you can see, here when we talk about these three statements over here, all of them are correct over here. Here you can see when we talk about the second one, mandamus will not lie against a company even though it may be a government company, because it is not performing a public duty, that is a for-profit organization. Okay, coming to the next one, any public-minded person can be a petitioner to move to the court to obtain a writ of quo warranto. That is also right. Option D would be your right answer over here. Okay, So here you can go through this particular you can say explanation over here, which we have already discussed. Now coming to the next part, we have already talked about the writs, but when we talk about the Supreme Court or the judiciary, that is a broader concept. So I have taken this liberty that I have added some of the static part of the Supreme Court of India over here, which you can go through, which can be asked. Okay, when we talk about the history and the evolution, so here they have talked about the regulatory acts from which the origin can be traced, and after that you will be seeing that the establishment of the Supreme Court of India under Article 124 in 1950. Article 124 is basically talking about the judges and the Supreme Court over here. So when we talk about the composition, strength is 34, that is 33 plus 1, okay, including CGI, we have 34 judges, okay, and judges are appointed by the president. Eligibility is there, he should be Indian citizen, high court judge for 5 years and advocate for 10 years, or he is a distinguished jurist in front of the president. Okay, so that is their tenure. If we talk about, that is up to age of 65, okay, or unless he resigned or been impeached by the president, and then salaries are determined by the parliament. Impeachment procedure, when we talk about, that is taken place in the parliament, but the removal will be done by the president. Okay, so that is about your Supreme Court. Other than that, some of the power or the jurisdiction which has been given, there is original jurisdiction, there is writ jurisdiction, there is appeals from the High Court which is there is a advisory jurisdiction. Here some of the articles are given. When we talk about the original one, that is Article 131, and then when we talk about the constitutional remedies, that is Article 32. So these article becomes important for you. Writ jurisdiction, that is given in your 139. When we talk about the appeals from the high courts, that has been given in 132, 33, 34, 36, and discretionary powers are also there. When we talk about the advisory you can say jurisdiction, president can actually refer certain cases for the advice, so that is given in Article 143. So here all these things you should remember. Coming to the others power, here you can see power to you can say punish for the contempt. Now this article is important, and that has been asked in the UPSC earlier. Okay, so that is why Article 129 becomes important for you. Then coming to the Article 137, that is talking about the Supreme Court review its own judgment. This particular thing has been asked in the that has been mentioned in the PYQ. So Article 137 becomes important for your next examination, etc. Then Article 141, Supreme Court decisions are binding on all the courts, that is there. Article 142 is talking about the Supreme Court as you can say order and the decrees of Supreme Court are enforceable in nature. Article 147 is talking about the ultimate interpreter of the constitution, final interpreter of the constitution. Now talking about the ad hoc judges, acting chief justice, etc., that is also been there are provisions which has been made over here which you can go through. Okay, so that is about it. You can take a screenshot, or you will be getting all these things in your PDF, so don't worry about that. Okay, now let's move further. Before that, how we are helping you here with respect to your prelims preparation. So we have various courses, we have test series. Here I'm telling you about the IAS Prelims Test Series 2025. Key features include the comprehensive coverage, subject-wise evaluation will be there, and the detailed explanation will be there along with the test. You will be getting the explanations as well. Okay, for more details you can call on this particular number, that is 87501 87501. If you have any kind of query with respect to the UPSC examination or the courses of by Drishti IAS, so in that case you can call on this particular number, or you can download the Drishti learning app, wherein you can get all these courses and the test series available which are available over there. Okay, now let's move further to the next question. Consider the following statement. Statement 1, the Supreme Court of India has held some judgment that the reservation policies under Article 16 Clause 4 of the Constitution of India would be limited by Article 335 for the maintenance of efficacy of administration. Now this is true, because when we talk about Article 335, okay, now that says that you can go for the reservation policies, but you have to make sure that the efficacy in the administration that stays there. That is one thing. Other than that, they also talk about the quantifiable data to be presented in front whenever it is required. So that is there. So when we talk about this statement, that is correct. Second statement, the Article 335 of the Constitution of India defines the term efficiency of the administration. Now again, in the first episode, in the second episode, we have discussed that there are certain terms which are again and again been asked. Okay, and they are asking you simple fact about that, whether it has been defined by the Constitution or not, whether it is mentioned in the Constitution or not. So here we can say that this term is not defined in the Constitution. It is not defined in the Constitution. Okay, so that is what is where, when we talk about the office of profit, when we talk about the term cabinet, when we talk about this particular term, that is efficiency of the administration, all these things are mentioned in the Constitution but not actually properly defined. When we talk about the contempt of the court, that is not defined in the Constitution. Okay, so that is there. So statement 1 is true, statement 2 is not. Option C would be your right answer over here. Okay, I hope that is clear. Now with that, it is your duty to go and make a list of these terms which I have just mentioned: contempt of the court, efficiency of the administration, office of profit, cabinet, all these terms which are mentioned in the constitution but not defined. Okay, so that is there. Option C is your right answer. You can go through this particular okay, or let's just talk about it. So when we talk about the reservation, there is one thing which has been discussed by the various you can say jurisprudence or the precedences in the Supreme Court. In the past 7 decades of the constitutional jurisprudence on reservation, the Supreme Court of India has consistently referred to the notion that is efficiency and merit while adjudicating validity of the various reservation policies. Court has held in several judgments, that is Indira Sahni case of 1993, M. Nagaraj case of 2006. When we talk about the Indira Sahni case, you must remember that there is a 50% cap which has been put over there. Okay, so that is also important. When we talk about 2-3 things which is important, Mandal Commission. Mandal Commission is important with respect to the reservation. Then Indira Sahani case. Then we have this M. Nagaraj case. Now this is your duty that you go through these particular cases over here. Okay, so that is there in the Indira Sahani and the M. Nagaraj, that the reservation policies are made under Article 16 Clause 4. The Constitution would limited by the Article 335 Clause 2, which provides for the maintenance of efficacy of the administration. That is there. Constitutional does not define this particular term. Okay. Now moving further, statement. Consider the following statement. Statement 1 is the pursuant to the report of H.N. Sayal Committee, the Contempt of the Court Act 1971 was passed. Okay, so that is correct. Coming to the next one, that is the Constitution of India empowers the Supreme Court and the High Court to punish for its contempt of themselves. That is also correct. The Constitution of India defines the civil and the criminal contempts. Again, they have mentioned the civil and the criminal contempt that is not been defined in the Constitution. Okay, so that is why this statement becomes incorrect. Now if you look at this particular, you can say, question and then go through the option, if the statement 3 is incorrect, so you will be removing the C and you can say D. So now you have two options, 1 and 2, 1, 2 and 4. Now answer depends on the 4, or even though if you don't know anything, you know that the civil and the criminal contempt has not been defined, so you can easily eliminate two options. Now you can take a chance to attempt this particular question. In India, Parliament is vested with the power to make laws on the contempt of the court. Okay, so that is there. Considering that, option B would be your right answer. Okay, now see, a committee was set up in 1961 under the chairmanship of the H.N. Sayal. Okay, he was the additional Solicitor General at that point of time, to examine the law and the problems related to the contempt of the court. Okay, now after that he has made some kind of reservation. The committee has made you can say recommendation on the issue over here, and with that they have come up with the Contempt of the Court 1971 Act. Okay, so that is there. Now when we talk about the contempt of the court, we were talking about the articles over there. We have seen that Article 129 of the Constitution is empowering the Supreme Court to punish for its own contempt, and similarly Article 215 is giving the same kind of right for the High Courts. Now when we talk about the contempt of the subordinate judiciary, for that High Court has the right. Okay, subordinate judiciary does not have the right to punish for the contempt as of now. Parliament can give such a right by making a law on that, but till now there is no such law. Okay, so Article 129 is talking about the contempt of the court with respect to the Supreme Court, and then Article 215 is talking about the contempt of the court in the High Court. Okay. According to the Contempt of the Court Act 1971, contempt refers to the offense of showing disrespect to the dignity or the authority of the court. Expression contempt of the court has not been defined by the Constitution, so we have already talked about that. Parliament is vested with the power to make laws on the contempt of the court as manifested in the enactment of the Contempt of the Court 1971. However, as understood by Article 142 Clause 2, the power to punish for the contempt is also constitutional power vested in the Supreme Court, which cannot be curtailed. So basically what they are saying is that that is a constitutional power, that is the power you can say that cannot be curtailed by the Parliament. So making sure that they are not violating Article 142 Clause 2, they can make a law. Okay, they cannot violate this particular article. Okay, so that is there. Now we can move further to the next one. With reference to India, consider the following statement. The government law officers and the legal firms are recognized as the advocate, but the corporate lawyers and the patent attorneys are excluded from the recognition. Now this statement is wrong, because when we talk about the advocates over here, so here law officer, government law officers, legal firms as well as the patent attorneys, these are also included as advocates. Okay, but corporate lawyers are not. Okay, so that is there. Considering that, statement 1 is wrong. Coming to the second one, Bar Council has the power to lay down the rules related to the legal education and the recognition of the law college. This is correct. Option B would be your right answer over here. Now, here you can see this has been asked in 2022. Considering that Bar Council becomes important for you, definition of advocates becomes important for you. What is the difference between lawyer and advocate? That becomes important for you. Okay, so please focus on these aspects as well. Now, coming to the next part, whatever we have discussed over here, that has been given over here. Let's see, the government law officers, legal firms, and the patent jurists are recognized as the advocates. When we talk about the corporate lawyers, they are kept outside the recognition of the definition of advocates. Okay, when we talk about the Bar Council of India, as I told you, that becomes important. So here some fact is written. This is a statutory body because it came through the Advocates Act. Okay, so we have an Advocates Act 1961 through which the Bar Council of India was made, and that regulates the legal practice and the legal education in India. So that is how you can solve the question. Next part, if we talk about, it also sets the standards for the education and provides for the recognition of the universities. So that is also there. Now, when we talk about the members of the Bar Council that are being elected from the lawyers in India. Okay, so that is something which you should remember from this aspect. Now, moving further, with reference to the Indian judiciary, consider the following statement. Any retired judge of the Supreme Court of India can be called back to sit as and act as a Supreme Court judge by the Chief Justice of India with the prior permission of President of India. Now, as I told you that there is the concept of ad hoc judge, there is the concept of the acting judge. All these things are there. Considering that, the statement 1 is correct over here. Any retired judge or any judge who has the qualification to be or you can say who has served as a judge of Supreme Court can be asked by the CGI to act as a judge of Supreme Court by the permission, prior recommendation of the you can say President. Okay, a High Court India has the power to review its own judgment as the Supreme Court does. Now they are saying that High Court has the power. That is right. High Court has the power to review its own judgment, but they are saying that as the Supreme Court does. Now, when we talk about High Court and Supreme Court, the power to review its own judgment in Supreme Court, it is explicit. Constitution talks about it, that they can review their own judgment, but through various precedences, Supreme Court has given this power to the High Court. Okay, so that is a implicit power and not explicit power. So considering that, you can say that that is not same. Supreme Court has explicit power because Constitution mentions it, and High Court has the power because of the interpretations. Okay, so that is why this statement becomes wrong. Option A would be your right answer. Okay, so let's talk about that over here. As per Article 128 of the Constitution, Chief Justice of India may at any time, with the previous consent of the President, request any person to sit and act as a judge of Supreme Court which is having a that particular person is having these following qualification. What is the qualification? Who has held the office of a judge of Supreme Court. Okay, so that is one thing, that who has been a judge of Supreme Court earlier, who has held the office of the judge of High Court and is duly qualified for appointment of a judge of a Supreme Court. That means that a person is qualified to be a judge of Supreme Court. He has served as a judge of High Court, or he has been a judge of Supreme Court. These are the qualifications for a person to act as a Supreme Court judge. Okay, coming to the next one, the review power of the High Court as a court of record are constructed by the Supreme Court in Raj Narayan case. As I told you, this power is intrinsic. That power has been interpreted by the Supreme Court in the Raj Narayan case in 1958. So High Court has the interpretative power, but when we talk about the Supreme Court has the explicit power which is conferred under Article 137. Now Article 137 becomes important for you. We have discussed all these articles in the Supreme Court section. Okay, so that is there. So here you can say that they do not have the equal power. Okay, so considering that, option A is your right answer. Now we can move further to the next one. With reference to the Constitution of India, prohibitions or the limitation or the provisions contained in the ordinary law cannot act as a prohibition or limitation on the constitutional power under Article 142. It could mean which of the following. Okay, now if you don't know this particular provision, okay, obviously we will be discussing the question, but the thing is, if you don't know about all these things which has been written over there, one hint is given, that Article 142. Now you know one thing that is clear, that Article 142 is related to the Supreme Court, because we have just seen Article 141, 136, all these articles from 124 till 142, 143, we know that that is related to Supreme Court. When we talk about the scheme of the Constitution, you should go with the scheme of the Constitution. You will be seeing that initially they have talked about the territory. After that, they have talked about the citizenship. After that, they have talked about the fundamental rights. After that, they have talked about the fundamental duties and the DPSPs. Okay, after that, you will be seeing that they have talked about the union. then they have talked about the state. Like that, there is a scheme of the constitution. Now, considering that, if you know the scheme of the constitution, you know that all the articles which are related with the Supreme Court, they are kept in a particular sequence. So considering that, you know that article 142 is about Supreme Court. Okay, now let's see the first statement. They are talking about the election commission, so that is wrong. Coming to the second one, that is talking about the Supreme Court, so we will keep that as an option. Coming to the next one, in the event of the grave financial crisis, the country president of India can declare the financial emergency. When we talk about the financial emergency, we know that the article with respect to the emergency are somewhere around 356, 360. This is your 360 is basically a financial emergency. So this statement is also incorrect. First is also incorrect. The state legislature cannot make laws on certain matter without the occurrence of the union legislature. Now this is also not there in the vicinity of 142. Considering that, option B would be a right answer. Now, just one hint that article 142 that has been mentioned over here, and you know that article 142 is related with the Supreme Court. You don't even know what is the matter behind that, but still that is a logical thinking which you should have that in the examination. Because if you look at the terminology of this particular question with reference to the Constitution of India, prohibition or the limitation or the provision contained in the ordinary law cannot act as the prohibition or the limitation on the constitutional power under article 142. Now this is confusing in itself. Okay, now if there is a question which is big enough, or that particular question is posing some kind of confusion, I would tell you that there is some kind of hint which is hidden in the question itself. That is why PYQ analysis becomes important. Okay, anyways, let's move further. This article 142 is about the Supreme Court over here. Let's discuss that. That is related to the when we talk about the Supreme Court, it is related to the decree, or when we talk about the complete justice, Supreme Court has power to make any kind of direction or pass any decree or order in order to do the complete justice. Okay, now what they are saying is that if there is a particular restriction in a particular law which is there, that cannot curtail this power of the Supreme Court. Okay, so that is there, which has been given in the article 142. Article 142 and advisory power of the, you can say, Supreme Court, these all articles are quite important for you. Contempt is important for you. Okay, so that is about it. Now let's move further to the next one. Consider the following statement. The 44th Amendment to the Constitution of India introduced an article placing the election of Prime Minister beyond the judicial review. Now, this is basically a 39th Amendment Act. And because of which, you know that there was this case, Indira Gandhi versus Raj Narayan case, okay, which we have discussed in the first one. When we talk about the basic structure, at that point of time, we have discussed Indira Gandhi versus Raj Narayan case. So that was after the 39th, you can say, before the 39th Constitutional Amendment Act. So that was the 39th Constitutional Amendment Act, wherein they have put the election of, you can say, Prime Minister, President, Vice President, etc. That will be out of the, you can say, ambit of the Supreme Court, and there will be another body which will be there, which will take care of the disputes with respect to such elections. So this statement is wrong. Coming to the next one, the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being the validity of the independence of the judiciary. Now this is correct, because when we talk about the 99th amendment of the Constitution, that is talking about the National Judicial Appointment Committee. Okay, and over here the role of executive was enhanced, and that is why Supreme Court said that it is against the independence of the judiciary, and that is why they have struck it down. Basically, the role of NGSC was to replace the collegium system. Okay, so considering that, we can say that option B would be your right answer, because first one is incorrect, second one is correct. Now there is nothing to discuss over here, because 39th Amendment Act, I already told you, that is with respect to keeping the elections of President, Vice President, Prime Minister, Speakers of the Lok Sabha and out of the ambit of the Supreme Court, and there should be a different body that should be made, a body constituted by the Parliament, to be vested with the power with respect to the resolution of the dispute in the elections of these people. Okay, coming to the 99th Constitutional Amendment Act, I told you that is about the National Judicial Appointment Commission. Okay, so that is about it. Now moving further to the next one. Consider the following statement. Statement 1 is the motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act 1968. Now this is incorrect, because Speaker can reject. Okay, on the basis of the merit, they can reject as well. Coming to the next one. So if you reject the statement 1, so A and D is eliminated over here. Coming to the next one, the Constitution of India defines and give details of what constitute incapacity and proven misbehavior of the judges of the Supreme Court. Now in the article 124, they have mentioned the grounds for the removal of the Supreme Court judge as well. In that grounds, there are two grounds which has been mentioned. One is your proven misbehavior, and second is your incapacity. Okay. Now they have mentioned the, you can say, these two grounds, but they did not define, or they did not give the details of it. Again, this is a term which should be added in your list. Okay. So that is, they're considering that second one becomes wrong too. So if you remove this one as well, coming to the next one, that is basically the details of the process of the impeachment of the judges of the Supreme Court of India are given in the Judges Inquiry Act 1968, which has been given over here. So this statement is correct. Okay, if you go through this particular logic as well, so you will be seeing that if 1 is there and 3 is there in a particular statement, you will be seeing that they have mentioned Judges Inquiry Act over here as well, and they have mentioned Judges Inquiry Act over here. So that might be a chance that impeachment procedures are given over there in the Judges Inquiry Act. Coming to the next one, if the motion of the impeachment of a judge is taken up for the voting, the law requires the motion to be backed by each house of the parliament and supported by the majority of the total membership of the house and by not less than 2/3 of the total membership of the house present and voting. So basically what they are saying is that there should be majority, I would say majority of the total membership and 2/3 of the present and voting. Okay, so that is the special majority which is required. Similar kind of majority is required in the removal of the president as well. Okay, so this is correct. So here 3 and 4 is correct. Option C would be your right answer. Okay, so here you can see option C is the right answer. This is the procedure, removal procedure, if you talk about. So this has been given in the Judges Inquiry Act 1963. When we talk about the removal procedure for the Supreme Court, the High Court, that is same. Now let's say the initiation. When we talk about the initiation, there should be a motion which is to be placed in the parliament in front of the speaker. That motion should be signed by a few members. Okay, so in case of Lok Sabha, if the motion arises in the Lok Sabha, 100 MPs should sign that. If the motion arises in the Rajya Sabha, 50 MPs should sign that. After that, there will be a committee which will be, now speaker will be accepting it or rejecting it, and then there will be a committee of inquiry. Okay, so in the committee of inquiry there will be 3 people, CJI or the judge of the Supreme Court. Okay, now if we are talking about the removal of the CJI, in that case Supreme Court judge will be the part of the committee. Now if we are talking about the removal of a Supreme Court judge, in that case the CJI will be the part of the committee, first thing. Okay, coming to the second one, Chief Justice of High Court will also be part of that particular, you can say, committee, and then a distinguished jurist will be there. Okay, so these are the 3 people which will be there. They will investigate the charges, they will take the evidences, witnesses, etc., and after that they will be submitting the report to the, you can say, finding to the parliament over here. Okay, so if the committee finds no guilt, proceedings will stop. If the committee finds them guilty, then they will be putting that particular report in front of the parliament, and the parliament will go for the voting. Okay, in that case special majority will be required, that is approved by 2/3 of the member present and voting and 50% of the total membership of the house. Once that particular resolution is passed by the parliament, then the president will go for ordering the removal. Okay, so ultimately appointment is done by president, removal is also done by president. Okay, I hope that is clear. Now let's move further. We have already discussed that particular thing over here in this particular question. Okay, you can go through this if you want to. Now coming to the next part, with reference to the Constitution of India, consider the following statement. Again, whatever I have explained over here, that has been given in this particular slide. For your convenience, I have put it over here, so you can go through that. Okay, now coming to the next question, with reference to the Constitution of India, consider the following statement. No High Court shall have jurisdiction to declare any central law to be constitutionally invalid. Now this is incorrect, because we know that High Court has such power. Earlier High Court did not, then after that High Court had the power. Okay, coming to the next one, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Now again, this is also wrong, because just now we have seen that the 99th Constitutional Amendment Act has been called out in the court and they have rejected it. Okay, 39th Constitutional Amendment Act, they have rejected that. So considering that, we can say that both the statement here are incorrect. Okay, so that you can see, Constitution 42nd Amendment, when we talk about, inserted various articles in the Constitution to curtail both the directly and the indirectly the jurisdiction of Supreme Court and the High Court to review the constitutionality of the law. They tried to curtail that particular power in the 42nd Constitutional Amendment Act, but in the next 43rd amendment, these has been reversed and the original position was imposed. Okay, there was this article 131A which gave Supreme Court exclusive power, exclusive jurisdiction to decide on the constitutional validity of the central law, thus deprive the High Court of that particular jurisdiction. So here they have taken away the power of the High Court, but in the 43rd amendment, again these particular you can say article has been removed, that 131A 226A, 32A, such article has been removed and the original position has been restored, wherein Supreme Court and the High Court, both of them has the power to review the constitutional amendments or the law which is against the constitution. Okay, so that is there. Then comes the Keshwanand Bharti case, which we have already discussed, the doctrine of basic structure that has been discussed earlier. Example has been given over here, that the 99th Constitutional Amendment Act, which has been reviewed by the court over here. Now, before moving further, we have IAS prelims course for you, that is including GS as well as CSET. This is an online course wherein you will be getting 500 plus hours of the classes. Watch time will be unlimited. That means that throughout the validity of the course, you can watch lectures any number of time. Okay, so for your revision, that becomes important. Then coming to the next part, that is 30 free tests will be included over here for GS and the CSET. Medium is English. For more details, you can download the Drishti Learning app or you can call on this number, that is 87501 87501. Okay, patch. So let's move further. Here we will be starting with the local self-government. Okay, in the local self-government, in the discussion when we were talking about the constitution and the schedules and the parts, over there we have taken some question with respect to that. Okay, when we talk about the part 9 or the 73rd Constitution Amendment Act, we have talked about these things over there. So I will not be repeating that questions because that does not make sense. But we will be talking about the other aspects or other question which has been asked. That is not many, because most of the time when we talk about the local self-government, you will be seeing that the focus is always on the panchayat or the municipalities, etc. Okay, so considering that, we will be taking the remaining question over here. So starting with the, if a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statement best reflects the consequence of it? Okay, this would prevent the transfer of land of the tribal people to the non-tribal people. Then coming to the second one, this would create a local self-governing body in that particular area. This would convert that area into a union territory, and the state having such area would be declared as the special category state. Okay, now here you can see this makes no sense. Okay, if there is a scheduled area in a particular state, that does not mean that that state will become a special category state. Okay, then coming to a second option C, this would convert that area into union territory. Now this is also not right. Now this would create a local self-governing body in that area. Now that is also not, automatically it will not create a local self-governing body. So here this would prevent the transfer of the land of the tribal people to the non-tribal people. Okay, so that is option A would be your right answer. Under Article 244, Clause 1 of the Constitution, the President may, by order, declare any area containing scheduled tribe as a scheduled area. Governor under the 5th schedule can make regulation with respect to this. Okay, again, scheduled area will be notified by the President. When we talk about a particular scheduled tribe, that will also be notified by the President. Okay, so that is there. Governor under the 5th schedule can make the regulation of that particular area. Prohibition and the restriction on the transfer of the land from the tribal to non-tribal people. Regulation of the allotment of the land to the tribal in the scheduled area. Regulation of money lending in the scheduled area. Okay, so that is about this particular Article 244. Now that becomes important, because if they have asked about a provision over here, there are high chances in the next few years they will be asking about the article as well. Okay, 244 you should remember. Coming to the next one. Here we are talking about the local self-government, because we have already talked about some of the aspects over here in the first episode. Here we will be talking about the 73rd and the 74th Amendment Act. Some provisions I will be telling you. Okay, so here when we talk about the local self-government, there are two kind of governments. One is the rural local government and the urban local government. Rural local government is basically your panchayati raj institution, and when we talk about the urban one, that is your municipalities. Okay, so let's see system of rural local self-government in India, that is under the panchayati raj institution, and for the urban areas we have the municipalities. Okay, 73rd Constitutional Amendment Act 1992 is the one where panchayati raj has got the constitutional status. When we talk about this, I would ask you a question that which state after independence, which state implemented the panchayati raj institution for the first time? Okay, for the first time, which state has implemented that? Okay, so that you can tell me in the comment box. Anyways, for the when we talk about the urban local government, 74th Constitutional Amendment Act was there in 1992. When we talk about the constitution provision, you can see that the part 9 has been added over here. The article 243 to 243O has been included with respect to the Panchayati Raj institutions. When we talk about the municipalities, so part 9A has been introduced, and 243P to 243ZG has been introduced over there. Then coming to the schedule added, when we talk about the you can say what kind of work that will be done, that is added in the 11th schedule. So for Panchayati Raj, 11th schedule has been added, wherein 29 functions has been added for the panchayats. And when we talk about the municipalities or the urban local government, so 12th schedule has been added, wherein 18 functions has been added for the municipalities. Okay, so that is the overall review of this. Coming to the type of institution in the rural local self government, so we have gram panchayat, we have block panchayat, jilla panchayat. Now these names will be different at different levels, but we know that there are three level institutions will be there. Okay, coming to the urban local government here, so there are various types like municipal corporation, municipalities, notified area committee, town area committee, cantonment board, township, port trust, special purpose agency, etc. These will be there. Okay, coming to the next one, central ministry. For Panchayati Raj, we have dedicated ministry, that is Ministry of Panchayati Raj, and for the local urban governance, we have Ministry of Housing and Urban Affairs, Ministry of Defence, Ministry of Home Affairs. Because when we talk about the Ministry of Defence, in the cantonment area, you will be saying that the administration of that particular area will be under the cantonment boards. Okay, so that is there about the urban and the rural local self government. Okay, coming to the next one, under which schedule of the Constitution of India can the transfer of the tribal land to a private party for mining be declared null and void? 3rd, 5th, 9th and the 12th. Okay, so when we talk about this, 5th schedule is the answer, which we have already discussed. Okay, because in the first episode I told you all the schedules, all the parts becomes important. They can directly ask a question from there. With respect to the tribal areas, we know that 5th schedule is there, and then in the 6th schedule there is a special provision which has been there for the you can say ATM 2. There are four northeastern states which I have already told you about, that will be there. Okay, now option B is your right answer. You can go through this particular explanation over here. That is some static part which you can go through. Article 244, again, as I told you that if they have in 2019 they have mentioned a provision which is from the article 244. Okay, again they have asked about the article 244, they have given the provision. There are high chances that they will be asking about the article 244 again. Okay, now constitutional post and the bodies. Here we will not go into details of these particular questions, because all the questions will be of similar kind. Okay, appointment, removal, all these things are there. So my suggestion to you will be to go through all the constitutional and the non-constitutional bodies, make a list of it, make sure that you are writing the appointment procedure, make sure you are writing about the appointment authorities, removing authority, all these things you should make a note of it. Okay, so consider the following organizations or the bodies in India: National Commission for the Backward Classes, National Commission, National Human Rights Commission, National Law Commission, National Consumer Dispute Redressal Commission. You have to choose the constitutional bodies. Okay, now simply if you have the list, you will be telling the answer over here. So National Commission for the Backward Classes, that is right, because earlier that was a statutory body. After that, that has been given the constitutional status. Then coming to the next one, National Human Rights Commission. Now this is not a constitutional body. Okay, coming to the next one, National Law Commission, that is also not a constitutional body. National Consumer Dispute Resolution Commission, that is also not a constitutional body. Option A is your right answer. That is only one, National Commission for Backward Classes. Okay, so I have given the list of the constitutional bodies and the non-constitutional bodies. Now it is your job to go into details of it. Okay, so here Election Commission, UPSC, State PCS, State Public Service Commissions, and then Finance Commission, National Commission for SCs, National Commission for STs, National Commission for Backward Classes. Okay, then that might not be over here. So that is National Commission for the Backward Classes will also be part of it. Okay. Then Special Officer for the Linguistic Minorities, CAG, Attorney General of India and Advocate General of the States, that is your constitutional bodies. Okay. Then coming to the next one, non-constitutional bodies, Planning Commission, which was earlier there. Now we have Niti Aayog. Niti Aayog is a body which has been created by an executive order. Then National Development Council, National Human Rights Commission, which we have seen, State Human Rights Commission, Central Information Commission, State Information Commission, Central Vigilance Commission, Central Bureau of Investigation, Lokpal and the Lokayuk. These are your non-constitutional bodies. Okay. Coming to the next part, that is which this already we have discussed, National Commission for the Backward Classes. That was earlier you can say statutory body under the act, that is National Commission for the Backward Classes Act 1993, and in 2018 that has been given the constitutional status. Now National Human Rights Commission, if we talk about, so for the protection of human rights, we have this act, that is Protection of Human Rights Act, PHRA Act in 1993. Now, considering that there was this particular body which has been established, and again in 2006 there was an amendment to this particular act. Okay, Law Commission of India is not a statutory body, that is a non-statutory body. Okay, that means that there is no law behind it. So there is a notification by the Ministry of Law and Justice. By the notification it has been created. Then coming to the National Consumer Dispute Resolution Redressal Commission, that is NCDRC. It is the quasi-judicial commission which was set up in 1988 under the Consumer Protection Act of 1986. Okay, I hope that is clear. Now let's move further. Miscellaneous. Herein we'll be discussing some of the miscellaneous questions or some of the questions which has been left. So we'll be talking about that. Okay, starting with the first one. With reference to the union government, consider the following statement. N. Gopalaswamy Iyengar committee suggested that the minister and the secretary will be designated solely for the pursuing the subject of the administrative reforms and the promoting it. Now, that question has been asked in 2021. Mostly you will be seeing that this is not part of their constitution or something like that is not there, but there will be some kind of reason in the current affairs, etc. that question has been asked. Okay, so considering that I have taken this question, so that is there. So this statement is wrong, because when we are talking about the this particular committee, they did not mention such kind of role that solely for the pursuing the subject of the administrative reforms there should be a department and the secretary should be there. So that was not there. So this statement is wrong. In 1970, the Department of the Personnels was constituted on the recommendation of the Administrative Reform Commission 1966, and this was placed under the Prime Minister's charge. Now this is correct. Option B would be your right answer. Okay. So this is something of factual information which is there when we talk about the Gopalaswamy Iyengar Commission, which is committee which submitted a report on the reorganization of the machinery of the government. Now, since they have asked this question, now it is your duty to remember the name of this particular commission and know that with which particular section this particular commission is related to. Okay, so in 1950s this commission was there. This report has not mentioned setting up a ministry or the secretary for the administrative reforms, so which we have discussed. Constituted in 1966. The first ARC presented a report on the personal administration in 1969. ARC suggested setting up a separate department for the personnel to be directly under the control of the Prime Minister, and with respect to that we have DOPT, which was established in 1970s, which we have discussed. Okay, now moving further, consider the following statement. Statement 1 is, according to the Constitution of India, a person who is eligible to vote can be a minister in the state for 6 months even if he or she is not a member of the legislature of the state. Okay, now if you look at this, prima facie you will be seeing that that statement is right, but the problem is that here they have mentioned a person who is eligible to vote. Okay, now a person who is eligible to become a member of that particular house, okay, that should be you can say appointed as a minister. So for that the age matters. Okay, when we talk about this person who is eligible to vote, the age is 18 years. When we talk about to become a member of a house, age is your 30 and 35, which is there. Okay, so considering that, you should consider that particular option over here, and this would be your wrong option. Okay, then coming to the statement 2, according to the Representation of the People Act 1951, a person convicted of a criminal offence and sentenced to imprisonment of the 5 years is permanently disqualified from contesting an election even after the release from the prison. Now that is not the case. After release of the prison, there is some time threshold is there. After that he can go for the election, and this time period is not 5 years, that is 2 years. Okay, both the statements are wrong. Option D would be your right answer. Okay, now in such situations the time period becomes important. Now other than that, Representation of the People's Act 1951 and 52, that becomes important. That does not mean that you have to go through the provision of the act, all the provisions. You have to make sure that all the important provisions you should know. Okay, so that is there. According to Article 164 of the Constitution, a minister who is not a member of the state legislature for any period of 6 consecutive months shall be ceased to be a member. Okay, so basically what they are saying is that a person who has been appointed as a minister and within 6 months he has to be the member of the house, from any constituency, he has to be appointed as a member of the house, then only he can stay as a minister. Okay, otherwise a person who is not a member, he can stay for at the position of the minister for only 6 months. Okay, so that is there. Now again, Article 164 becomes important for you because that has been asked, the provision has been asked earlier. That means that they can ask you about the article as well. Coming to the next one, the provision allows a non-legislator to occupy a post in the Council of Ministers, including the office of the Chief Minister, for 6 months, as I told you. Then within the 6 months, he must become the member either by the election or by nomination of the House of the state legislature. Otherwise, he cease to be a member. Okay, when we are talking about the state legislature, that is the case. When we talk about the parliament also, that is the case. Okay, as to become a member of the state legislature or the parliament, one must not be less than 30 years in case of the legislative council and not less than 25 years age in the legislative assembly. Now similarly for the Lok Sabha and Rajya Sabha, you will be telling me the ages in the, you can say, comment box. Now, according to the section 8 clause 3 of the Representation of the People's Act 1951, a person convicted of any offence and sentenced to imprisonment for not less than 2 years, again not 5 years but 2 years, shall be disqualified for the contesting election of the MP or MLA from the date of such conviction, shall continue to be disqualified for a further period of 6 years since its release. So basically after the release, up to 6 years he cannot contest the election. After that he can. So that is there. Coming to the next one, which one of the following suggested the governor should be an eminent person from the outside of the state and should be detached figure without the intense political links or should not have taken part in the politics in the recent past? Okay, so what they are saying is that which commission has given this recommendation? First, ARC, Rajmanar Committee, Sarkaria Commission, or the National Commission to review the working of the Constitution. Now all these commissions becomes important for you because they have mentioned it. Okay, now it is your job to go and check that what these commission has talked about. Now when we talk about this particular element over here, option C is your right answer. That is about Sarkaria Commission. Okay, so that is there. Sarkaria Commission is a commission which is there for the, you can say, the center state relation. It was there. Okay, so here you can see the Sarkaria Commission when it was formed. So it was appointed in 1983 and it has given its report in 1988 and it has talked about the role of the governor and the, you can say, president's rule, etc. So that is under article 356 and 370. That is there. Sarkaria Commission recommended that the governor should be an eminent person from outside the state so that he is not part of the state politics. Okay, so we have seen over here. Now coming to the next one, how many delimitation commissions have been constituted by the government of India till December 23? Okay, this has been a question which has been asked in 2024. Now obviously these kind of questions can be, you can say, difficult question because you might not be knowing this. Okay, but the problem is that that question is not from the static part, that is a question from the current affairs, because when we talk about the December 2023, you must have seen that the delimitation commission which is due in the, you can say, 2026, that is due over there, and talking about the census which was 2021 is the last census on which that particular delimitation you can say commission should be working. But the thing is, this census has also been delayed. Jammu and Kashmir delimitation has happened. So considering all these things, delimitation commission was in news and that is why they have asked this question. So when we talk about this over here, so option D is your right answer. 4 times it has been made. So here that in 1952 with the act, that is 1952 delimitation commission act which was there, and then in 1962 the act was there, and on the basis of which in 1963 they have appointed the commission, and then there was this 1972 act. So a commission was appointed in 1973, and then there was this 2002 when this last time that particular delimitation commission was formed. Okay, so that is there. You can see 1952, then 1963, 1973 and 2002. These are the 4 times when we have actually gone for the creation of the delimitation commission. Okay, moving further, what are the duties of the chief of the defense staff as the head of the Department of the Military Affairs? Okay, now permanent chairman of the chief of the staff committee, that is fine, exercise military command over the three service chiefs. Okay, now when we talk about the role of chief of defense staff, it does not command the military you can say exercise military command, so that is not there in the duties of him. Okay, so here if you eliminate the second one, so you'll be seeing that this is gone, this is gone, and this is also gone. Let's say principal military advisor to the defense minister of all tri-services matters, so that is correct. Option D is your right answer over here. Okay, so let's see, chief of defense staff, it is a body which was created on the recommendation in 2001 by the group of ministers. So there was this recommendation in 2001 by the group of ministers which was tasked with studying the Kargil Review Committee. Okay, in 1999 there was this Kargil Review Committee report was there, and what the task was of this group of ministers to review this particular report. Okay, the post of CDS was also established on the recommendation of the Shekhatkar committee. Okay, Shekhatkar committee was also there with respect to the, you can say, in that particular committee they have also recommended the position of the CDS that has to be created. The duties and the function of the CDS over here. So the function to function as the permanent chairman of the chief of staff committee, which we have already seen over here, the statement 1. Then coming to the section 1, however, CDS will not exercise any military command. Okay, so that role of the CDS is to ensure the coordination between the tri-services and not to go for the military command. Okay, then it will be acting as the principal military advisor to the Honorable Raksha Mantri or the Defense Minister, to administer the tri-service organization, agencies and the commands, to be a member of the Defense Acquisition Council chaired by the Honorable Raksha Mantri. Okay, so that is about your CDS. Coming to the next one, Northeastern Council, that is there, was established by the Northeastern Council Act 1971 subsequent to the amendment of NEC Act in 2002. The council comprises the which of the following members? Governor of the constituent state, that is right. CM of the constituent state, that is also right. 3 members to be nominated by the president, that is also right. The Home Minister of India, now that is wrong. Okay, so 1, 2 and 3 is right. Option A is your right answer over here. Okay, now here you can see option A is your right answer. Here these are the people who should be the member of it. Okay, now moving further, consider the following statement regarding the Nari Shakti Vandan Adhiniyam. That is also a question from the current affairs. Provision will come into effect from the 18th Lok Sabha. Now 18th Lok Sabha is already working, so that is not the answer. That will be coming into picture after the delimitation commission comes into the picture in the from the next election. That will come into picture. Okay, so statement 1 is wrong. Option C would be a right answer. 2 and 3. This will be enforced for the 15 years after becoming an act. Okay, so when we talk about this particular reservation, when we talk about the Nari Shakti Vandan Adhiniyam, that is talking about the reservation to the women in the, you can say, Lok Sabha and the state assemblies. So for that they have made a provision in the Nari Shakti Vandan Adhiniyam. So this reservation will be valid for the 15 years. Okay, like other provisions which were initially valid for the 10 years and then they have been extended. So that was there. So initially it will be, you can say, valid for the 15 years, and the future we will see what happens. There are provisions for the reservation of the for the seats of the scheduled caste women within the quota reserved for the scheduled caste. So that is also there. Okay, so 2 and 3 is your correct answer. Option C would be your right answer. Okay, when we talk about the constitution amendment, that is 106, because for the reservation they have to go for the constitutional amendment. Constitution 106 amendment 2023 reserves 1/3 of the all seats for the women in the Lok Sabha, state legislative assemblies and the legislative assemblies of the NCT of Delhi. Okay, including those reserved for the SC and STs. This act shall come into effect after the exercise of the delimitation commission undertaken, which we will be seeing after the census, that we will have the delimitation commission. Okay, after the 18th Lok Sabha election, census and the delimitation commission are done immediately, and then act will be implemented. So that is because, you know, this particular question was from the 2024. Now let's see when we will be having this delimitation commission or the census, and after that this particular law will come into force. Okay, the reservation will be effective from the publication of the census conducting following acts commencement and the indoors for the 15 years period, which we have already seen. The act will also apply to the seats reserved for the SC and STs for the Lok Sabha, state legislature and the NCT of Delhi. Okay, coming to the next one, before that we have ISGS foundation course for you, under which we will be providing 1000 plus hours of the classes. Unlimited view time will be there, which I already explained that for the period of the validity you can watch these classes unlimited period of time, and then there will be prelims test series which will be included in the course free of cost. And here we will be you will be getting the details of this course on the Drishti Learning app, so you can download the Drishti Learning app or you can call on this number, that is 87501 87501. Okay, now moving further, with reference to the Home Guards, consider the following statement. The Home Guards are raised under the Home Guards Act and the rules of the central government. Now when we talk about the Home Guards, that is not under the central government, these are under the state government. Okay, so here this statement is wrong. The role of Home Guards is to serve as an auxiliary force to the police in the maintenance of the internal security. This is correct. To prevent infiltration on the international borders, coastal areas, border wings, Home Guards battalions have been raised in some states. So that is also correct. Option B would be a right answer, because both the statement 2 and 3 is correct over here. Okay, so that the same thing which is written over here has been written over here. So you can go through this. When we talk about the Home Guards, they are raised under the Home Guards Act and the rules of the state and the union territories, and not under the central government. Okay, now let's move further. Consider the following statement with respect to the national flag of India. According to the Flag Code of India in 2002, one of the standard size of the national flag of India is 600 mm to 400 ms. They are talking about the mm, that is 60 centimeters by 40 centimeters. That is not the case. That is not a standard size. Okay, we will be talking about the standard size, what sizes are there. Then coming to the next one, the ratio of the length to the height should be 3:2. Now this statement is correct. Okay, So this is correct. The first one is wrong. So here you can say option D would be your right answer, wherein they are talking about the statement 1 is incorrect and the statement 2 is correct. Okay. So option D is your right answer. When we talk about the standard size, that is given over here, 6300 by 4200 mm, then 3600 to 2400, 2700 to 1800, 1800 to 1200 mm, and then 1350 to 900, and 900 to 600, 450 to 300, 225 to 150, 150 to 100. Okay, so these are the sizes. In these are basically your ratios of length is to breadth. Okay, so that is there, which you should remember. Coming to the next one, national flag shall be rectangular in shape, which is there, and the ratio of the length to the height. Okay, length to the height. So that is the ratio of basically length to height. Okay, that should be 3:2. If you go through all these things, you will be finding that that ratio is there. Okay. Coming to the next one, with reference to India, consider the following statements. Unauthorized wearing of the police or the military uniforms, the Official Secrets Act 1923, knowingly misleading or otherwise interfering with the police officer or the military officer when engaged in their duties, that is the Indian Evidence Act. Now, if you look at this, they are talking about a procedure which has been followed by the police, and then if someone is interfering it, okay, so that is a kind of a crime, that is some kind of you can say a violation which you are doing. So that will not be part of the Indian Evidence Act, because in the Evidence Act they are talking about how evidence should be taken. They are basically talking about the nature of the evidence, the procedure of the evidence. So this will be wrong. Okay, coming to the unauthorized wearing of the police or the military uniforms, that is correct, Official Secrets Act. Then celebrating gunfire which can endanger the personal safety of others, that is, yes, that is the provision which is punishable under the Arms Amendment Act 2019. Okay, so here two are correct. Option B is your right answer. When we talk about the second one, that is also true under the Official Secrets Act. Okay, so that is there. I have given the table over here under the Official Secrets Act 1923. These two sections are there. Regulate matters related to the national security, espionage, sedition, and the unauthorized disclosure of the sensitive information. Criminalize spying, sharing classified information, unauthorized use of the uniforms, and interfering with the armed forces. Okay, so that is there. Punishable punishment includes imprisonment up to 14 years, fine, or both. Section 7 states that no person near a prohibited place shall obstruct, knowingly mislead, or interfere with the police officers or the armed forces personnel on duty. That is their Arms Amendment Act, which we have seen that this particular provision is under the Arms Amendment Act. Okay. Moving further, this is the same thing which we have discussed over here, that has been given in words over here. So you can go through this. Coming to the next one, with reference to the anti-defection law in India, consider the following statements. That is talking about the 10th schedule. Okay, so that is there. The law specifies that the nominated legislature cannot join the political party within the 6 months of being appointed as the member of the house. Okay, now this is incorrect, because within 6 months he can join, after that he cannot. Okay, then second is the law does not provide any time frame within which the presiding officer has to decide on the you can say defection case. Okay, so that is there. When we talk about the 10th schedule, that is related to the disqualification. Over here you can see these are the members. Okay, these are the members, and elected members voluntarily given up the membership. There is a person who has been electing, who has contested the elections from a particular party, and after that he has actually left the party. He has you can say left the membership of the party. In that case, that particular person shall be disqualified. Okay, elected members voluntarily gives up the membership of the political party. In that case, he will be disqualified. Coming to the next one, an independent elected member joins a political party. A person who has contested the elections independently, and now after the election he is joining a political party. In that case also he will also be disqualified. A member votes against the party in the house. Okay, when we are talking about the voting in the house, that is done on the directions of the whip. Okay, and that particular person has voted against the direction of the whip. In that case also he will be disqualified. Then a member abstain from voting. The member of the political party has abstained from the voting without telling the party. In that case also that will be disqualified. After the expiry of 6 months, a nominated member joins the political party. Within 6 months he can join, after that he cannot. Okay, so that is there. So here you can see the statement 1 is wrong. The law does not provide any time frame within which the presiding officer has to decide on the defection case. Now that is perfectly right. So option B is your right answer. Now here you can say, therefore any nominated member can join the political party within the 6 months. That is there. As per the law, Speaker of the House has the power to decide on the disqualification of the members. The law does not prescribe any time period. So final authority with respect to the disqualification under the anti-defection law lies with the Speaker. Okay. Coming to the next one, which one of the following best defines the term state? Now they are talking about the definition of the term state. You can go through all the options over here. What I'll tell you is that what are the constituent of the state. When we talk about the state, what should be there? One is the territory. One is territory. That is important, that a state should have a territory. Okay. Coming to the next one, that is basically your people or the population, or you can say the citizens. That is there. Third is sovereignty. State should be sovereign. Okay. And fourth is government. These are the four things which a state should have. If in the definition these four things are there, that means that that particular statement is right. Okay. A community of person, that means population. Okay. So that is there. Permanently occupying a definite territory, so that is also there. Population is there, territory is also there. Independent of the external control, that means that that is the body which is sovereign. Okay, external control is not there, so that is also there. Then coming to the possessing and organized government, that means that they are having the government as well, so that is also true. That means that option A is your right answer. Okay. Coming to the next one, a politically organized people of a definite territory possessing an authority to govern them, maintain law and order, and protect their natural rights, and safeguarding their means of substances. Okay. Now this is being very specific. Okay. There can be a state, but the thing is that state might not be able to do all these things. A failed state can be there. Okay. So considering that, this becomes wrong. A number of person who has been living in a definite territory for a very long period of time as their own culture and tradition and the government. Now number of people who are living in a particular territory for a long period of time. Okay. That means that considering that if there is a person or you can say a community which comes to another state, let's say there is a state A. This is state A, a community which is coming from outside. This state A has made you can say provisions that this community will be residing in this particular area. After a long time they can claim that we are a state, so that is not the right definition. Okay. Coming to the next one, a society permanently living in a definite territory with a central authority. Now again they are being very specific, central authority. That means that if there is a decentralized authority, that means that it cannot be a state. So that is why all these statements are wrong. Okay. That has been given, the definition has been given over here, which I have already discussed with you, so you can go through this. Now we can move further to the next one. With reference to the India, consider the following statement. Judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in the police station and not in jail. Now when we talk about the judicial custody, that means that the person or the accused is in the, you can say, custody of the judicial magistrate. That is fine. When a person is in the judicial custody or the under the custody of the judicial magistrate, that particular person will be inside the jail and not in the police lockup. Okay, not in the police lockup. So that is why this particular statement is wrong. Coming to the next one, during the judicial custody, police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Now that is right. If there is a person who is under the judicial custody, the officer in charge of the investigation has to take the prior permission from the judicial magistrate to go for any kind of investigation. Okay, so option B is your right answer. Okay, here you can see accused is under the police station when we talk about the police custody and the judicial custody. So in the police custody, person will be under the police station, under the police control, and that will be under the police station, and police can go for the interrogation. They can go for the interrogation, they can ask questions over there. Okay, that is there. Accused has limited rights over here, and primarily that particular person will be in the police custody for the investigation purpose. Then often leads to shorter and the more incentive interrogation period. Okay, so police custody is a shorter period. Okay, that is there. Coming to the judicial custody, an accused is under the judicial control, under the judicial magistrate, typically in a jail. Police needs court's permission for the interrogation, which we have already seen. Accused has more protection under the court supervision because it is under the court's custody. So that is you can say that more protection will be there and involves longer detention with more oversight. So that is there about the judicial custody and the police custody. Okay, now we can move further. With reference to India, consider the following statement. When a prisoner make out a sufficient case for the parole, cannot be denied to such prisoner because it becomes matter of right. Now when we talk about parole is not a matter of right, it is a matter of discretion of the authority. Okay, so here that is wrong. Okay, when we talk about the furlough is a matter of right. Okay, so that is there. State governments have their own prison release on the parole rules. Now this is correct. Option B would be a right answer because the state government has their own rules. Okay, so here you can say parole can be looked at from the perspective of a privilege and not a right. Okay, so that is there. Other than that, here you can see in this particular table, they have talked about the difference between the furlough and the parole. Since we are talking about the parole over here, that is a short-term detention, or you can say when we talk about the person who wants a parole, that means that he will be out for a short term. That is there. It can last for a duration of 1 month. Okay, a period of release does not count towards the total period of the sentence, and it has not been seen as the matter of right. It is not a matter of right. When we talk about the furlough is a matter of right. Okay, it is maximum of 14 days. And when we talk about the reason in the parole, it is given to a prisoner for a specific reason, because this is not a matter of right. So for a specific reason only it can be given. Okay, when we talk about the furlough, for that there is no reason which is needed on some period of time on the occasions that particular furlough can be given. Granting authority is the divisional commissioner, and DIG of prison is the granting authority over here. Okay, so that is about the parole and the furlough. They have talked about parole. They have asked about the parole. That might be a place where you should know about the furlough as well. Okay. Now moving further to the next one, that is in the context of India, which one of the following is the characteristics appropriate for the bureaucracy? Okay, so they are talking about what is bureaucracy over here. An agency for widening the scope of the parliamentary democracy. Parliamentary democracy, when we talk about, that is the function of legislature. When we talk about the bureaucracy, that is part of executive. So that is incorrect. Coming to the next one, here you can see an agency for strengthening the structure of the federalism. Again, that is also not true, because when we talk about the bureaucracy, that has one function, that is implementation of the law. Okay, so that is executive. An agency for the facilitating political stability and the economic growth. Now that is also not true, because political stability is more like when we talk about the government function or the political parties function. Then coming to the next one, an agency for the implementation of the public policy. Yes, public policy which is been built by the legislature, now you have to implement it. So that is your option D, that is your right answer. You can go through the explanation over here, which is given over here, I guess. Okay, anyways, consider the following statement. Statement 1 is, in India, prisons are managed by the state government with their own rules and the regulation for the day-to-day administration of the prison. Okay, so that is there. Coming to the next one, statement 2, in India, prisons are governed by the Prisons Act 1894, which expressly kept the subject of the prison in the control of the provincial governors. Okay, so here you can see both the statements are right over here. So this statement, when we are talking about the state government has their own regulations, so that is right. And why is that? Because in the Prisons Act in 1984, where the prison as a subject were kept under the provincial governors. Okay, government. So we are still following that particular law. So that is why the statement 2 is the right explanation of statement 1. Option A is your right answer over here. Okay, so you can go through this because they have given the same thing. Coming to the next one, this is the basically definition of the you can say your bureaucracy, which was misplaced from this particular slide. So anyways, just please note that is given over here. Okay, now for your IAS Prelims 2025, we are having a batch, that is IAS Prelims 2025 General Science batch. Earlier we have discussed about the GS and the CSAT one. So in that also, if you are interested only for the general science, you can go for this course. We are having 400 plus hours of the classes over here. Unlimited view times will be there. Prelim test series will be included over here. For more details, you can call us on 87501, or you can download the Drishti Learning app. Now with that, we will be ending our discussion over here. We have discussed the polity in 3 different episodes. If you have not watched that, you can go and start watching now, because for your prelims it becomes very important that you go through all these things. Other than that, there will be a comment which will be pinned. There will be a MCQ question in the comment, so you can attempt that question and answer to us in the comment box. And in the next episode, we will be talking about the PYQs from the history. So stay tuned with us. With that, have a nice day. Thank you, and please subscribe the channel.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.